Can my child's surname be changed? This is asked more frequently than you might think, actually. The answer is yes, but there's got to be certain factors in play before that can happen. And that could either be by agreement or that could be as ordered by a court. If a child is indicating that they want to change their surname, and this can happen following separation, particularly where married and the wife has taken the husband's surname, and then the wife on divorce separation might go back to what was their maiden name, and then there's different surnames for the child and then perhaps the parent who's caring for them. If the child is of a certain age, and I would say probably 9, 10, 11 plus years old, it may be possible for that child to take their own legal representation and advice about whether they could go ahead and change their surname. For it to happen in that scenario, both the parents, those that hold the rights and responsibilities for that child, would have to be in agreement, or it could be an application to the court by the child, and it would be against both parents, and ultimately the sheriff would have to decide if it was in that child's best interest to change the surname. If the child is much younger and it's a view of one of the parents that the surname should be changed or that is best, then it would be that parent that would take the action. And if they don't have the agreement of the other parent who's got rights and responsibilities, they would have to raise it at court. And again, the test would be best interests. It's quite an interesting and quite involved area of the law, simply just to look at a surname. But you can't just go ahead and do it unilaterally. You do legally need the agreement of the other parent. And then if you have that, or you have a court order, ultimately the registrar could issue a new birth certificate with that child's changed surname.